Afternoon, Your Honors. You all issued an opinion in December in the Quezada case, which discussed federal preemption at quite some length, and we didn't have an opportunity to brief it. But one of the things that you said is that the court should not lightly infer an intention to negate the state's exercise of sovereign power. And one of the things that you said, that that's based on a respect that sovereigns have for each other. And so what I'm here today to urge you is that respect and comedy are a two-way street. And that what is going on here is that California is totally disrespecting the federal policy. And to get to that point, I want to push very deep into what that policy is. And I want to do a quick run through all the statutes. We've talked about Section 22. He's mischaracterized it. The part about regulations under law referred to mining districts. It was regulations of mining districts, and so far as not inconsistent, is a straightforward adoption of obstacle preemption. There's a large body of authority construing this. There are other sections of the mining law, I think in 35 and so forth and so on, which talk about state law, the state law related to the acquisition of title, miners fighting over claims, all this kind of things. There's a role for state law, but even going back to the turn of the century, it was always the law that whatever the state did, to quote the Butte City case, could not interfere with the liberal spirit of the mining laws. Now, later we come out to sections...
It remains the case, does it not, that the state has not banned mining. The state has said you just can't mine using this technique.
I would agree that it is true that Mr. Rinehart can still use a teaspoon. He can use a gold pan. But this gold is underwater, and you can't breathe underwater without equipment using motors. It places the valuable minerals in his claim completely off limits. What's more, there is no factual record before this court.
Well, suppose somebody decided that the best way to get gold out of a river is to lower a depth charge. Because, boy, that would blow gold right up into the...
I got it. That's what the law professors say. We can have an atomic bomb to dig these things out.
I wouldn't go quite that far, but help me with the depth charge example.
Okay, the depth charge example is that we have a large body of case law on what reasonable environmental regulation is. We have the case of the United States versus Richardson. You're not allowed to use dynamite unless it's really, really necessary. So in that case, they told the miner, you can't use dynamite, you've got to use this core drilling method instead. The courts have developed a body of law over 100 years to narrow and protect environmental values on the federal regulatory side.
But to pick up on Justice Corrigan's question, what aspect of the depth charge problem or mining activity in general can the state regulate under your theory?
Under my theory, it can do what Granite Rock told it can do. It can have reasonable environmental regulations that do not interfere with the federal policy. And what is missing so far, and what I really want to try and hammer home today, is the nuances of that federal policy. Because when you march through all the statutes, you'll see that there's a fundamental difference and inconsistency between the federal view and the state view. And I'll just jump to the end before I go back, which is the federal view is the minerals are there. They're in a place. Okay? They're not anywhere else. The only way you can get the minerals out is by taking them out of that place. And you can't take them out of that place without causing some environmental impact. It's inevitable. And so the whole structure of federal law, not just the statute we've discussed before, but the Federal Land Policy and Management Act, the Forest Management Acts, all of these statutes talk about unnecessary and undue degradation. This may be analogized to what you have in CEQA. In CEQA, you have a circumstance where an agency in California wants to do something, and there's significant environmental impacts. And the agency can do what's called a statement of overriding concern or something like that, where the thing says, okay, we understand there's significant impacts, but the policy is we want to do this for policy reasons. And that's what Congress has said for minerals. We have a statement of overriding concern because of things like 21A's, national security, industrial needs, this need for stable mineral industries, all these things that are destroyed by moratoriums. We have overriding policies here. And what happened instead? The state comes in and says, we've got environmental laws, we've got water quality laws, we've got air quality laws, we've got disposal laws, but these laws and the standards that are in these laws, the reasonable environmental standards, they can't stop the mining. And we don't like the mining. We just want the mining to stop. And we've got to pass a new law that says we're going to prohibit it.
Well, okay, that's a lot. How do we, as a court, cash out the principle of reasonableness that you want us to apply here?
You look at 612, and you look at the federal statutes that explicitly give authority under the water pollution control standards. Things like water control standards are right there in the federal law. You can do that. And there are standards. But the standards don't bar this activity because this activity is so utterly insignificant that it doesn't violate the standards. That's what's really going on here.
So
Instead, we have to switch to a prohibitory approach instead of an approach of reasonably addressing the environmental effects of the use. And that's what we say we cannot do.
You're asking us to essentially second-guess the agency's determination here of both the potential harm of suction dredge mining and then the proper way to go about ameliorating those harms.
Well, I got a better argument than that. The better argument than that is that under the obstacle theory, what the state's motives are essentially functionally irrelevant. You said that in this Martin case, that's in Medtronic. What we look at is the federal objectives and whether they are interfered with. And the federal objective is to have this overriding policy that says sometimes we're going to have some significant effects. And we can't have a state statute that says, oh, you've got to fully mitigate every effect we can think of. And the history of that provision indicates that it's expressly designed as a prohibition.
What about the early, the late 19th century ban on hydraulic mining?
Yes,
I mean, that seems even...
He's wrong. He didn't ban hydraulic mining. You want to know what that statute says? The Public Resources Code, section 3923 or whatever, it says, the business may proceed so long as there's no material injury to these lands downstream. Because this was real harm. This is like the whole rivers, it's washing out bridges, it's covering thousands of acres of farmland with rocks. These are effects that are miles away, and it was an attention to environmental effects on a specific case-by-case basis. It was early environmental regulation.
So you're going to argue with your opponent here about whether or not the dislodging of mercury into waterways that go into people's houses is or is not sufficiently harmful?
Of course, because what he didn't tell you is mercury is like gold. It winds up in the dredge and they take it home. And what they're fighting about is there's this 1% little piece that goes back in and falls back where it was, and some of it might drift a little further downstream. Other states, they run these programs, which is the dredgers help collect the mercury. You know, the papers that they have written on this thing they are fraudulent.
So, counsel, is there any factual circumstance under which a moratorium on suction dredging would count as a reasonable environmental regulation as you understand it? Any fact pattern, any scenario?
Not where it has been underway for decades without killing or hurting anything, and the federal agencies are essentially expressly authorizing it. Because that's what we got here. We put in the record the Forest Service decision. The guy comes in for his Forest Service approval. Forest Service comes back, where's your California permit? He said, well, that's not reasonable, they won't grant one. Forest Service takes it out. Well, we're regulating, it's fine. To answer your question, maybe if you had this new method of mining, okay, nuclear bomb method, all right, and somehow the federal agencies were all asleep, and somebody said, well, the nuclear bomb method is so wild that, maybe we should study it, and the feds didn't say anything. But that's not what we've got here. We had a functional system in place for decades, and nobody ever got hurt. There were no dead fish, there were no sick people, there were no traces of anything anywhere that could be measured. There is nothing. And
doesn't the regime have to leave space for the state to be able to study whether or not the effects are as minimal as you say, or more on the nuclear bomb scale?
Sure, it can study. It's
been
studied it for years. It's studied it for years before the moratorium.
So at what point, in your view, does it become impermissible for the state to study those environmental effects? What's the difference between permissible studying?
Nothing ever stops the state from studying. What we say the state is not allowed to do is enact what is in character a prohibition. And that's why we have the 8th Circuit, we have the Federal Circuit, we have the Supreme Court of Idaho.
So the state has to let a particular technique that may or may not have tremendous environmental harm continue while it's studying to determine exactly how severe or not severe those harms are, in your view?
It has to let it continue.
So in other words, the state can't say, we're going to put a halt to this particular activity while we study whether or not it has unreasonable environmental effects.
If you turn over all of preemption law and you put aside the interference of federal obstacles and you start revising preemption law to reflect the strength of the state's motives, I think you need a record to do that. You don't have that record in this case. I mean, we filed a lot of stuff, but It's not a record in the trial court. It's not, a lot of it they say is not properly before the court. We can demonstrate beyond a shadow of a doubt that there is nothing here that should give rise to this concern, if the court got into
Okay, so now we're talking about two different questions. One is the extent of preemption law, and the other is whether or not the decision makers here made a reasoned and informed decision. You say they didn't because your studies and the opinions of other people disagree. That's a little different from preemption law. So I think it would be helpful to disaggregate those two arguments. One has to do with whether or not they're right, and I'm discerning that perhaps you think they're not. The other is the degree to which the federal government has intended to preempt this kind of state action.
Let me return to that.
And as you return to it, let me focus the inquiry in this way. The Federal Mining Act goes back to 1872. The views of governments generally and people around the country were a little less refined with regard to environmental protection then than they are now. So I'm wondering how that factors into the equation.
Well, the Act is not in splendid isolation. What about the Endangered Species Act? I mean, if this thing took Endangered Species Acts, it would be subject to being shut down under the Endangered Species Act instantly. Okay? What about the Water Quality Act? There's 50 different acts to protect environmental values.
That may be true, but we're not examining those.
Right, but why do we need? Why? If we're worried so much about the state and the environmental values, why do we have to authorize the state to flatly prohibit any effective mining whatsoever when it's got all these other laws? I mean, to return to your point now, to answer the question, 1872, the effects that they were thinking of then were these damage to downstream lands and things like that. You can see that in 30 U.S.C. 51, which actually goes back to 1872. Then we come up to 1955, and we have there the no material interference standard. And it's quite clear that federal agencies can't prohibit or can't severely restrict to the way these people did. They can't do it. Then we have the Minerals Policy Act in 1970. Then we have the overarching Federal Land Policy Management Act in 1976, I think it was, by which time we had the Clean Water Act, the Clean Air Act, all the environmental statutes were in place. And again, the focus was on undue and unnecessary environmental impacts. This whole federal approach that gives the overriding policy of we have to have some impact to give the minerals out is what the state is frustrating. It is frustrating that through this device of prohibiting and saying you can never do it until there are no effects at all. And the effects that they're talking about are really wild. It's not about fish. The regulations say there's no harm to fish. Those were the regulations that weren't good enough. And that's where we are. We're underwater with the fish. They come in with things like, well, there might be birds, or let me take another one. Traditional cultural properties. When you're underwater in a river boiling with boulders down every winter and so forth, there's nothing there. There's no, Native American temples or anything out there. So they came up with the idea that the whole river is a traditional cultural property, and for the miners to be present in this traditional cultural property is a significant impact, and that's got to be fully mitigated. Well, how do you do that? No miners. There's no other way. I mean, and the water quality thing. The Water Board, this legislature has expanded the ban now and said, we're going to give you the power to prohibit it. And what did the Water Board say? They already are on record saying there's no way to eliminate the impacts except to prohibit the thing entirely. We can't have zero impact without prohibiting it. That's what the state wants. Zero impact. And that is what is, like giving the finger to the federal policy. It is not the respect that is due to a coordinate sovereign. So that's what I'd like to try and leave you with is there is a real powerful conflict of policy here. There is the federal sovereign that says we have got to get minerals out, and there's just going to be some effects that we can have reasonable regulation. We'll trust the agencies to deal with this, but we can't just say, I'm sorry, there have to be no effects whatsoever. And that's what California is saying, and that is an obstacle. It's clearly an obstacle. And it's because it's so clearly an obstacle